Is an injured worker limited to workers' compensation benefits when injured on the job? We'll talk about exceptions to workers' compensation limitations right now on the LawWorks.
From West Virginia Public Broadcasting.
Closed captioning for the LawWorks is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The LawWorks is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
Once upon a time, unless an employer deliberately injured or killed an employee, all the employee could receive for work-related injuries was workers' compensation. That's changed a bit. My guest is attorney and former West Virginia Supreme Court Chief Justice Richard Neely. Richard, thank you for joining us again.
Oh, I'm happy to do it.
What's workers' compensation?
Workers' compensation is an administrative procedure by which a worker who is injured can receive payment for his medical bills, as well as payment for being off work if he's off work, sort of like Aflac, right? And if he has a disability as a result of an accident, say he loses his arm, or he loses his hand, he can then get what's called a permanent partial disability, or if he fell off a ladder and is paralyzed from the waist down, he can get a total disability, permanent disability, in which case he would get payments for the rest of his life. It is a system that works reasonably well for minor injuries because it is fairly competent at paying medical bills. It is far less efficient for taking care of people who have had major injuries because the awards are actually very small. It's a system that responds to various kinds of unintended dynamics. For one thing, workers' compensation tends to be overused. There are lots of workers out there who don't want to work. There are lots of workers who would rather sit home, watch television, and drink beer, even if they're only getting $800 or $900 a month or a week, than go out and work a solid 8 hours. So there are lots and lots of fraudulent workers' compensation claims filed. And because there are fraudulent claims filed, the workers' compensation procedure for sifting through these claims is extremely complicated, and it's very difficult to get any kind of a serious workers' compensation award without hiring a lawyer. You have to get a workers' compensation lawyer who is a specialist, and there are not very many of them in West Virginia anymore because of the limits on fees that are imposed by the workers' compensation system. So the workers' compensation system, as you said in your opening, is very good for giving quick, non-contested relief for things like medical payments and also for being off work. I mean, if you fall and break your leg, it's pretty obvious that you're off work because of a work-related injury, and workers' comp will regularly send you a check every week or however often they pay to allow you to eat and support your family while you're off work.
And that was the purpose of the workers' compensation system in its original inception.
It was. What has happened is that the pressure for overuse by people who want to abuse the system and go on workers' comp as an additional 6 weeks of paid vacation, right? Suck the money out of the system so that the people who are really seriously hurt don't really get what they're entitled to and what they deserve. The same thing, by the way, is true of veterans benefits. If you asked a bunch of soldiers who were on a plane going to Vietnam, how should we divide up the veterans benefits? They'd all say, well, the guy who loses his eyesight or loses his arm or is really hurt badly should get almost all of it. Well, what about the person who has a minor hearing loss because he was an artillery officer? He'll do. That's what people would have decided before they went into combat, when nobody knew what was going to happen. After people come back from combat, most of the VA benefits are paid to people who have 10 and 20% disabilities. And the people who are, have never gotten out of a wheelchair since they left Vietnam get very, very little in comparison to the total amount of money that goes into veterans benefits.
And the same is true in the workers' compensation system?
The same is true in the workers' compensation system, except in the workers' compensation system, you have a lot of claims that are filed by people who either think they're going to get fired and they figure they better preempt the system and get themselves on workers' comp, they have a back injury or this or that. It's filtering out the fraudulent claims that makes the workers' compensation system so fabulously incompetent. If we didn't have anything except honest claims, people who are injured would get paid and treated much, much more fairly.
But we do have a lot of honest claims. The major industries in West Virginia are farming, timbering, coal mining, and those are, I believe, the three most dangerous industries to work in.
They are very dangerous, and there are lots and lots of really honest claims that don't get anywhere near the kind of compensation that people deserve. And that brings us then to the whole issue of the evolution of the Mandelitis cause of action.
We're talking about exceptions to workers' compensation. My guest is attorney and former West Virginia Supreme Court Chief Justice Richard Neely. I'm Dan Ringer, and this is The Law Works. So about 35 years ago, the law in West Virginia changed a bit. Right.
We did it in a case, I was on the Supreme Court at the time. Justice McGraw wrote the majority opinion. And the case was called Mandelitis. And what happened was that Mandelitis worked in a sawmill up in Elkins. There was a huge rotating saw bigger than this table. The owner of the sawmill took the guard off the saw. Mandelitis went to him and said, look, I don't want to operate this saw without a guard because it's dangerous. The owner said, either operate the saw without the guard or hit the road, because putting that guard on there slows down production. So Mandelitis had to do it, otherwise he'd lose his job, and he cut his arm off. He sued on the grounds that this was an intentional injury. And we agreed that this was an intentional violation of a known safety standard that was done for the purpose of increasing production and was done knowingly, not negligently, by an employer.
It wasn't a matter of the employer saying or thinking, I know you're going to be hurt, I'm glad you're going to be hurt, I want you to be hurt, get in there and cut your arm off.
Right.
But Mandelitis and other people had complained, and the safety standards said, this is so dangerous, don't do it. And in fact, that saw had been red tagged by safety inspectors.
Right. So that was the beginning of this, what is now called a deliberate intent cause of action. If you have been injured in a factory or in a coal mine, and you have been seriously injured, if there was a safety violation, you can go into the court system and sue for all of your damages. Now, you have to be able to find a safety violation. There are a number of us whose expertise in life is knowing the federal mining regulations and the OSHA regulations. I can always find a safety violation. I have never yet failed to find a safety violation. And you laugh, but what happens, law is not something that was intelligently designed. You know, you see this, you see the blind justice, you know, the woman with the blindfold holding the scale, and the scales are in balance, right? Well, the scales might be in balance, but they're in balance with two 500-pound weights on them. Because every time there's an outrage, the system responds by creating something to counterbalance the outrage. In Manolitis, the outrage was that workers' compensation wasn't paying people and were tying them up in knots in procedural appeals and hearings, et cetera, before they ever got anything. And so in response to that, we said, look, when people are seriously hurt because some employer has deliberately violated a safety standard, we ought to let them sue. And so we did. We crafted that under the intentional injury exception to the statute. What the legislature then did was come in, and actually the legislature followed my opinion in that case, which was technically a dissent, but was also a concurrence, where I said that the standard ought to be that if there's a violation of a safety standard, and if the employer knows about it, then we have an intentional injury.
So it's not an inadvertent violation?
No, it's not an inadvertent violation. But what you... And the reason that this is brought in is because workers' comp doesn't compensate people who are seriously injured. People who are seriously injured have a nightmare out there trying to live the rest of their lives. Now, they'll get Social Security disability if they're, you know, if they have a lawyer who'll go and fight that particular administrative nightmare. And they will get some kind of workers' compensation payment. But I have had lots and lots of clients who are totally disabled and will never again find work in West Virginia, regardless of what they do or how hard they try. And they have gotten 17% permanent partial disability or 30% permanent partial disability. Because workers' compensation figures that if you could find work as a doorstop in Southern California, you're not totally disabled, which is, of course, nonsensical. People who have been coal miners all their lives may have fabulous skills, might be a mine electrician, which is a really hard technical job that requires lots of training and lots of certifications. But it doesn't apply to civilian electrical work. I mean, I suppose you could wire your own house, but essentially, you're not a licensed civilian electrician. You're a licensed mine electrician, and the kind of electric work you do in a mine is different from what you do in a building like this. So, Manolitis was one of these jury-rigged creatures that the law creates all over the place to try and compensate for some other outrage. And the other outrage is the fact that workers' comp is bureaucratic. It's negative in that it looks at every claimant as a false claimant, you know, as a malingerer. It takes a long time, and you have to hire a lawyer. And the thing about Manolitis cases is, these intentional injury cases, is that in my partner Mike Callahan's opinion, in my opinion, there are only about 35 lawyers in West Virginia who actually know how to do these cases. They are very technical cases. If you use the wrong word in a pleading, you can get dismissed with prejudice on the pleadings, right? If you use the word negligence, for example, you are out of court. You have to craft the thing very carefully. And so if you have a Manolitis, if you've been injured, if people have been injured, or your husband was injured, or your children were injured, for heaven's sake, don't go to a lawyer who advertises serious personal injury, we're interested in you, blah, 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 because those guys, generally speaking, don't try cases, they settle cases. Go to your local lawyer who does wills and deeds and say to him, would you refer me to one of the people in West Virginia who specializes or has a large practice involving intentional injury cases or Manolitis cases? That's extremely important because you see the big firms, Jackson and Kelly, Bowles Rice, Flaherty, Sensenbaum, and Nassau, they have whole teams of lawyers who do nothing but defend these cases. They do nothing all day but defend. I mean, I work with Flaherty Sensenbaum all the time. There are 5 or 6 guys that I see all the time.
They're defense lawyers.
They're defense lawyers. They do nothing except Manolitis cases. The guy who heads the department is an extremely competent lawyer as well as a professional engineer. So he not only knows all the law, his name is Chris Brumley, he not only knows all the law, but Chris also knows all of the ins and outs of mine engineering and industrial engineering, and he's a quick read on all of the technical stuff. But these are guys who specialize. Plaintiffs' lawyers, the people who bring these cases for the folks who are injured, may have 3 or 4 of these cases a year. But the rest of the time, they're doing other things, you know. I mean, yesterday I negotiated a doctor's contract with CAMC. I mean, you know, I mean, you go in and out, as you know, because you're a plaintiff's lawyer, and you know, do this stuff all the time. But we're always going from here to there. The bad guys have got their own bad guy specialists, and they do only bad guy work. So you have to have somebody who is at least as well read into the problem as the bad guy specialists. And any general practice lawyer in West Virginia will know who does these cases well.
It's important to recognize that this is a very specific area of law, because the general rule is you get hurt on the job, you get paid by workers' compensation, and when you can go back to work, you do. But this is a case where somebody's really suffered.
Part of the reason that there are only about 35 people in West Virginia who do this is because these cases are very expensive. That's how we sort out the false claims from the real claims. The lawyers, when they take one of these claims, have got to front anywhere from $20,000 to $50,000 of expenses, because they need expert testimony, they need vocational evaluations, they need forensic accounting help to find out what the guy's lost wages are, etc. Lawyers who are operating on contingent fee aren't going to spend 30 grand of their own money on a case that they aren't going to win. So you don't find very many frivolous Manolitis cases in court, you know, unless they're brought by an idiot. But the serious lawyers don't take Manolitis cases that aren't gilt-edged, because the expenses are a serious disincentive.
The lawyer in a contingent fee case is essentially betting that the client is going to receive more as a settlement or as a jury award than the case costs to prepare, plus the time that he or she has invested into it.
Correct. Correct. So that lawyers who are working on contingent fee are very careful to filter cases so that they don't have cases that are losers. Because a loser not only costs you a lot of money to work it up, but you're also out, you know, hours and hours and hours of time. That's the difference between Manolitis and workers' comp. Workers' comp is flooded with cases of people who are malingering, while Manolitis only has people who have got injuries in excess of $100,000. I don't believe that I've ever settled a Manolitis case for less than, and I don't think I've ever settled one for $100,000. I think they've all settled for more than $100,000. Because those are the only cases that you can really work up. If, for example, if you have your thumb broken because of a safety violation, it absolutely is not worthwhile bringing a Manolitis case. You know, a broken arm is not worth bringing a Manolitis case. It's only if you have, I did one a couple of months ago where a guy was ordered to operate a huge piece of equipment where the seat springs had been broken, so that there was no cushion. I mean, this machine was almost as tall as this room, right? I mean, it was a huge machine used for quarrying. So the seat didn't have a spring to it. So it was early in the morning, the light was bad, and this guy hit a chuck hole, and the machine dropped about 5 feet or 6 feet, and it just absolutely destroyed his back. It just he
compressed everything.
He compressed everything, and he hasn't been able to walk normally ever since. Now, he had problems before. I mean, he had, as we all have, I don't know about you, you're a young man, but
you're right.
You get
Thank you.
But you begin to get arthritic changes in your spine right. Just naturally with age. But anyway, he went from working every day and frequently working overtime to being absolutely unable to take any job at all. So that's the kind of case that you take to mantulitis, right? You don't take the case of the guy who simply broke his arm,
We saw ads years and years ago about the personal injury lottery and accusing trial lawyers of milking the cow and taking in marginal cases and turning them into something big. Mantulitis-based cases are not like that. They can't be like that.
They're not like that because of again, you surely don't want to take one of these cases to an amateur. And your local practicing lawyer, he'll not take the case himself. He might refer it and do some of the windows and floors, and take a piece of the fee, which is perfectly appropriate. I mean, that's what the storefront local lawyer is for. A big piece of his job is not only taking care of your deeds and your wills and settling with the insurance company in your car crash case. It's also to know who to go to when there's a problem that requires a real specialist.
It's very much like the British system of solicitors and barristers.
Right. Exactly.
The storefront hometown lawyer should recognize her or his limitations and refer out a lawyer who is, I can't say a specialist, we're not allowed to say specialties in law in West Virginia, but who knows what they're doing.
Right. Exactly.
What do you say, though? I can hear people yelling at their screens right now saying, this is what is establishing the unfavorable business environment in West Virginia. We can't do business there because of this giveaway program in workers' compensation.
What do I say?
Yeah.
I say excrement of the bovine quadruped.
You don't agree with it?
Well, it's silly. The legal system is designed to try and give people a level playing field. There are lots of people, I'm one of them, who are born with a silver spoon in their mouths, okay? They tend to be the folks who run industry. They tend to be the folks who run banks. They tend to be the folks who are out there even as heads of law schools and universities. They don't understand just how hard it is to make it in Man, West Virginia, or to make it in Elkins. They don't understand the pressures that the ordinary guy has. And when torts are all kinds of things, not just mantulitis cases, but people coming along and just destroying your property, bringing in a bulldozer to fix to do a right-of-way, and with a bunch of clowns who destroy property that's nearby, and you call the gas company or you call the electric company or whoever it is and say, would you come out? And they tell you, no, go fly a kite, right? Those kinds of problems require lawyers to go in and try and solve them. Life is hard out there, and our tort system is not one bit worse than the tort system in New York or the tort system in South Carolina or the tort system in a lot of other states. There are states that are more conservative than West Virginia. Indiana's one, Virginia's another one, but Maryland isn't. In New York, the tort system doesn't work because the courts are too crowded. The courts in New York are completely incompetent because it'll take you 6.5 years to get to a jury trial.
They're incompetent because they're overwhelmed.
They're incompetent because they're overwhelmed. They're underfunded and they're overwhelmed. The nice thing about West Virginia courts is that they're basically pretty well funded. The only really underfunded court in the state is the family court.
And with that, we're out of time. I hope we can get together again sometime. We've got other things we can talk about. Richard Neely, thank you for joining us. Thank you also for joining us. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes.
The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.